Hello and welcome to this All About Age webinar from Gowling WLG. We'll be focusing on some fascinating age discrimination cases and some of the wider policy and HR issues that are emerging. And I'm joined today by Liz Wood, who's a director in our combined Human Resource Solutions team. Hello, Liz.
Hi, Ian.
And by Ruth Ormston, who's also Principal Associate, also in our CHRS team. Hi, Ruth.
Hello.
So Liz and Ruth will be presenting for about 40 minutes, and there's going to be time for some of your questions at the end. Just before we get started, just some housekeeping points. You can ask questions at any time. Just click on the Ask a Question tab, type your question in, and then click Submit. And we're going to try and answer as many of those questions as possible in the time available. And we've also got a couple of polls, and these are just going to flash up on your screen, and it would be great if you could participate in one of those. So now, to go over the agenda of what we'll be covering, over to Ruth.
Thanks, Ian. So in this webinar, we're going to just give you a brief refresher on objective justification, looking quite a lot of focus and detail at some recent cases on this, touch on potential policy developments, and finally, as some of you may have noticed, there has been a general election recently, so we'll end with some comments on that. But before we get started, over to Ian for our first poll.
Yeah, so this is being labelled Objective Justification, a refresher. So we'll just go over to that poll now. And what we're asking you is, can both direct and indirect age discrimination be objectively justified? So the options should be there on screen for you, yes, no, or I don't know. So you just fill in one of those and let us know what your response to that is. We're just getting our few responses to that now. So just give it a few seconds to let people respond to that. And with pretty much everyone having voted, I'm going to pass to Ruth to give us the answer to that.
Thanks, Ian. Well, I'm not going to give you the answer straight away, but it will come up, don't worry. So the next slide, we look at direct discrimination. Direct discrimination is set out in Section 13 of the Equality Act 2010, and here it prohibits less favourable treatment on the grounds of age. Age here capturing apparent age, a specific age or an age group, and a comparator or a hypothetical comparator is required. This applies to both employers and trustees, so trustees are directly covered by the Equality Act and can't discriminate against people. If we then move on to indirect age discrimination, contained in Section 19 of the Equality Act, indirect discrimination occurs where you have an apparently neutral provision, criterion or practice which is applied, but that puts or would put employees or members of a particular age or age group at a disadvantage and does put or would put the claimant themselves at that disadvantage. So this is sometimes a little bit trickier to spot than direct discrimination, I would say. Unlike the other protected characteristics in the Equality Act, such as race, sex, disability, uniquely with age, both direct and indirect age discrimination can be objectively justified. That is, it won't be unlawful if it can be shown that the treatment or the provision, criterion or practice is a proportionate means of achieving a legitimate aim. I think the majority got that right on the poll question. So there are two limbs to the objective justification test here. One, is there a legitimate aim? And importantly, in all cases, costs alone can't form a legitimate aim as an employer. So you can't just say you've treated somebody differently on the basis of age because it's cheaper. Having established a legitimate aim, you then need to look at whether or not it's proportionate, i.e. appropriate and necessary. Was the treatment or the provision, criterion or practice both appropriate and necessary in terms of achieving the aim that you had? And this requires a balancing act between the legitimate aims of the employer or the trustees, for example, and the impact on the employee or the member. And I'm now going to hand over to Liz, who's going to look at objective justification in some recent cases.
Thanks, Ruth. So two of the most important and potentially far-reaching age discrimination cases we've seen this year have been in relation to pension scheme changes. And these are likely to be highly relevant for employers and trustees of occupational pension schemes that provide defined benefit or final salary benefits, because so many schemes have over recent years or are currently planning to change the structure of their pension scheme so as to manage the scheme's liabilities. And these cases consider how those kind of scheme change exercises might give rise to age discrimination case laws. They're not just relevant to pension scheme changes, however. They are important reminders of the different ways in which the courts and tribunals might approach the question of objective justification. Interestingly, both cases involve attempts to soften the blow for older workers when defined benefit pension schemes have been changed by putting in place transitional or tapering arrangements. So the first case is that of McLeod, and this was an employment tribunal decision handed down in January of this year. And this case involved changes to the pension scheme offered to High Court and Crown Court judges in the context of the government's concerns that the existing pension scheme needed to be restructured so as to reduce costs. And after much consideration, the government introduced a replacement pension scheme, the new judicial pension scheme, which provided less generous retirement benefits. The government was very conscious that there might be some judges who were relatively close to their retirement age and for whom it was felt that they needed additional protection. So when the old scheme was closed and judges were moved to the new scheme, transitional protections were put in place for members of certain ages, depending on their years of pensionable service and their normal retirement date. And this resulted in mass age discrimination claims from 210 members of the judicial system who claimed that transitional tapering protections were age discriminatory. So what was the potential issue with the transitional tapering arrangements? Well, essentially, the judiciary were divided up in three ways. So there were unprotected judges who were moved to a new, less generous scheme, and they had no transitional protection. And these were mainly younger judges. And then you had taper protection judges, so the middle column, whose normal pension age was between 2022 and 2025, and they benefited from tapered protection. So instead of moving to the new scheme immediately, they were transferred to that scheme at the end of that transitional period. And then those whose normal pension age was much sooner, so sooner than the other two cohorts, and they were allowed to remain in the old scheme, and they were the protected judges. So you can see why, based on the structure of these transitional arrangements, that there was a risk of age discrimination claims being brought, because the more generous treatment was granted to those who were older, and younger judges felt that they were being discriminated against. Now, the government accepted that the transitional provisions involved less favourable treatment of the claimants because of age, but that they said that the transitional provisions were a proportionate means of achieving a legitimate aim. And the legitimate aim put forward in this case was to protect those closest to retirement from the financial effects of pension reform. So essentially, the government was saying that the older judges would be more likely to have made fixed or concrete plans for retirement, which they would find difficult to change if their pensions were changed very close to retirement. On this basis, the differences in treatment were justified and therefore lawful. So what did the judge say? Well, as we've mentioned, there were two tests to be satisfied in order to objectively justify a claim of age discrimination. Firstly, establishing a legitimate aim, and then showing that the means adopted to achieve that aim are proportionate in the circumstances. In McLeod, the judge was critical of the suggestion that protecting those closest to retirement from the financial effects of pension reform was a legitimate aim, and much of the criticism came down to the judge's concern that insufficient thought had been put by the government into considering why the tapering provisions had been put in place in the first place. And it's clear from the evidence given that the decision had been made by the government to protect judges very early on, particularly those who were closest to retirement, but there wasn't a great deal of evidence about why the government had considered this necessary. And much of the evidence seems to be linked to the fact that other public sector pension reforms have followed a similar approach, and the unions strongly wanted these kind of transitional arrangements in place for this scheme as well. And the tribunal said the lack of precision in formulating that legitimate aim doesn't mean that it can't be justified, but the court did need to look at the wider context to see if there was a legitimate underlying aim in this case. The Employment Tribunal concluded that the government's rationale for introducing the tapering, based on the idea that the reforms would most adversely affect those closest to retirement, and these nearest to retirement would be in particular need of protection, was a generalised assertion. It was critical of the fact that government had come to this conclusion very early on, but without really thinking about the evidential basis for doing so. In particular, the tribunal noted that no evidence had been put before it that any of the claimant judges had fixed or concrete retirement plans, which would be difficult to change, more so, for example, than the case of younger judges. Indeed, the tribunal found that the contrary was true. Not only was there no evidence, it said, that the older judges would suffer greater hardship than younger judges, but actually the evidence was consistently to the contrary, noting, for example, that younger judges might have their own financial commitments, for example, house mortgages or dependents. So the legitimate aim that had been put forward was not a legitimate aim, it was no more than speculation. Now, the tribunal didn't have to consider proportionality, but it did go on to do so in this case. And again, it said that there was a real critical assessment which was needed here in considering the question of proportionality. Were the means adopted appropriate and reasonably necessary to achieve the legitimate aim? And here, the judges compelled to transfer from the old scheme to the new scheme suffered an extremely serious adverse impact on the value of their pensions, particularly by comparison with the protected judges, but also those protected by the transitional tapering provisions. And the effect of these provisions overall was that the younger unprotected judges would suffer significant losses. In particular, there was a 10-year transitional protection period, and the tribunal judge was very critical about why that hadn't been thought through. There was no research or analysis that suggested that perhaps maybe 4 or 5 years might be sufficient as a transitional period rather than 10 years. So in conclusion, the balance was not properly struck. There was a failure by the government to show that a shorter period would not have achieved the legitimate aim. Then we had the Sargent decision just a month later in February of this year. So this was another tapering arrangement with a different result at the Employment Tribunal. So it was also about the same context, so the government was looking to make changes to various public sector pension schemes in order to put them on a more sustainable footing for the future. And again, discussions with the trade unions were in no small part influential in terms of the decisions put in place, a 10-year transitional arrangement, does it sound familiar, which was intended to soften the blow for firefighters who were within 10 years of the normal retirement age, this year and this time under the firefighters' pension scheme. So the transitional provisions put in place, very similar. You had 3 sets of membership groups, individuals who are going to be put immediately into the less generous firefighters' pension scheme, those active members who were within 10 years of the scheme's normal pension age, and they were able to remain in the old scheme until they retired. And then you also have the transitional protection for those within 10 to 14 years of their normal pension age, and they would get the tapered provisions. So what were the arguments put forward by the government in this case to justify why they'd had the taper? Well, there were more coherent, I think, legitimate arguments put in place. There was a more coherent rationale, so there were 4 reasons put forward as legitimate aims: protecting those closest to normal pension age, member expectations, so members would expect that their pension entitlement wouldn't change significantly when they were close to retirement, preventing a cliff edge between the protected and the unprotected groups, and the taper would achieve that, and also ensuring consistency across the public sector, where similar changes were being made to the other pension schemes. As such, the government argued in Sargent that the aims were legitimate and the means adopted were proportionate. So where did the judge land in this case? Well, interestingly, in Sargent, the judge was aware of but chose to disregard the decision that had been made and handed down just a month before in MacLeod. And that's not an unreasonable approach. Employment tribunals' decisions are not binding on other tribunals. But it is very interesting, and it has brought an extremely different outcome, because here the judge concluded that the introduction of the transitional arrangements for the firefighter scheme was not age discriminatory. So why did she come to a different conclusion to the judge in MacLeod? Well, in Sargent, the claimants argue that the legitimate aim must explain why the older group is being protected. A legitimate aim can't be established unless there is a social need to show that those nearer retirement are in greater need of protection, and more evidence simply was needed to show that this was the case. The judge here disagreed. She was much more willing to accept the latitude of the government, the employer, here, to determine its legitimate aims. including that political considerations might form part of those aims. And here she relies on previous case law, which said that justifications based on moral or political considerations might not be capable of being established by evidence, but nonetheless might be legitimate aims. The judge also relies on a number of cases which stress the wide degree of margin available to member states, i.e. governments, to determine their legitimate aims for treatment. And so while she was willing to accept that there might be good reasons for treating different age groups differently, she didn't seem to want to know what the evidential basis sitting behind those reasons might be. So firstly, she accepted that the stated aims in this case were indeed legitimate, those 4 reasons that we saw in the previous slide. She then moved on to proportionality, and she was willing to accept that, again, the government had a pretty broad decision-making ability to decide, firstly, whether the legitimate aims were proportionate, but also whether they struck that necessary balancing act between achieving those objectives and the impact on the individual members in question. And she rejected the claimant's arguments that the impact on the individual firefighters was catastrophic and unfair. She accepted that a line needed to be drawn somewhere. That was a social policy choice, and inevitably some individuals would be disadvantaged. Overall, she found it was reasonably necessary for the government to draw the line at some point, and therefore the proportionality test had been met. So what's the difference between these 2 cases? Well, given the similarity of the issues, the background, a similar approach to tapering, the arguments made by the claimants, it makes sense that these decisions are both now on appeal, given how different the outcomes were. But is there sufficient difference between the 2 cases to justify the different outcomes? Well, there isn't entirely the same set of facts. McLeod concerned very specific circumstances faced by members of the judiciary. Sargent considered that of firefighters. But actually, that aside, they are remarkably similar, being about employers putting in place transitional arrangements intended to soften the blow of pension scheme changes for older employees. And so I think much of the difference in outcome lies in the different judges' approach to very similar facts. In McLeod, the judge's key concern being a lack of proper analysis of the justifications for the tapers, so the legitimate aim or aims. By contrast, in Sargent, the judge's ability to accept the legitimate aims being put forward, particularly because the government, the judge believed, had a very wide discretion to determine those legitimate aims. And I think at this stage it's very difficult to predict where an appeal court will land on this, but we definitely watch this with interest. So where does it leave employers for now? Well, I'd suggest you take care in introducing tapering provisions if you're introducing scheme benefit reductions. This risks age discrimination claims, as we've seen. And even if on appeal it's decided that the tapering provisions in the cases we've seen here were not discriminatory, these might be difficult to rely on as grounds for introducing some sort of transitional arrangements if you're not a public sector employer. If you do introduce tapering provisions, consider the rationale for doing so. Don't make assumptions about the impact of, for example, a scheme closure on the affected employees. Older employees might be more vociferous in demanding protections, and unions might be on their behalf, but it might not factually be the case that they're the cohorts that are going to be most vulnerable when scheme changes are made. The greater impact might be on younger workers. Once you've established the rationale, consider the impact on the affected members. Would there be a disproportionate impact on certain age groups? And if so, could a less discriminatory taper be adopted instead? Take care when you're making decisions based on union involvement. Some cases, including the McLeod decision, talk about union agreements, but they also make it clear that just because you have union sanction doesn't mean that an otherwise discriminatory practice will then become lawful as a result. And finally, document those decisions. Put a paper trail in place to justify what your legitimate aims are and the proportionality test that you need. I'm now going to hand over to Ruth to consider 2 more recent age discrimination cases.
Thanks, Liz. And just a reminder to everybody on the webinar that you can keep submitting questions. So ask questions at any time by just clicking on your Asking a Question tab. Type in your question and then click Submit, and we'll try and answer as many of those as we can at the end. But now on to another case involving the public sector. This time we're looking at police officers. So this was a class action involving around 200 police officers and was brought by them against the chief constables of 5 separate police forces. To set the context, this involved something called Regulation A19, which was a piece of legislation which allowed compulsory retirement of officers on the grounds of efficiency of the force. And in particular, it allowed compulsory retirement after officers had become entitled to a pension of at least 2/3 of average pensionable pay, which would generally be achieved at around 30 years service. As a result of the wide-ranging austerity measures affecting a number of public services, including the police in 2010, it was decided by some police authorities that all officers potentially within the ambit of this regulation A19 would be required to retire, save for some very limited exceptions. And it's probably worth pausing to note at this point that police officers are not employees and their office will only terminate unless there's some misconduct or capability upon retirement. So it wasn't possible to deal with this need to make cutbacks and efficiencies by implementing redundancies here. And as a result of the application of Regulation A19 by a number of forces, the officers who had been made to retire brought claims of indirect age discriminatory. Because clearly this would apply only to those who'd accrued a certain level of pension, usually after 30 years of pensionable service, so it was going to have a more disproportionate adverse impact on the older officers. The Employment Tribunal agreed with the officers, saying that A19 had been indirectly age discriminatory, and it upheld the officers' claims, saying that the practice of requiring the retirement of nearly all of the officers in the forces who could be required to retire under A19 was not a proportionate means of achieving a legitimate aim. The Employment Tribunal looked at other ways the forces could have achieved the same cost savings, such as part-time working or encouraging people to take career breaks, for example. But this went on appeal to the Employment Appeal Tribunal, and they allowed the appeal of the forces and held that the application was not discriminatory, and the Court of Appeal agreed with that decision, so agreed with the Employment Appeal Tribunal. So why? Well, the Court of Appeal held that this was not age discriminatory because the wording of A19 in itself, whilst potentially discriminatory, was separate from the way in which the forces had adopted or applied A19, and that wasn't a further act of discrimination. So in the absence of a statutory provision such as this, any decision to limit the selection pool to employees with at least 30 years service could be potentially age discriminatory. But if a statutory provision makes it unlawful to include anyone with less than 30 years service in the pool, the selection method is inevitable, and a claim for unfair dismissal or age discrimination therefore fails. The court questioned the tribunal's take on the decision-making process of the forces, i.e. looking at whether or not they could have made a decision on another basis or achieved cost savings in a different way, saying that the emphasis should be on whether the outcome of this decision is justified. So the legitimate aim here was to reduce officer headcount to the fullest extent possible, and the measure taken was proportionate because no other option was available. Because of the absence of any general power to dismiss serving officers, the use of A19 was the only way in which that aim could be achieved, and there was no legal way to reduce numbers on the mass basis with the same certainty. So this was a fairly specific piece of public sector legislation. Could it be of wider application? Well, the case could be of relevance if you're looking at the effects of the application of a particular piece of legislation. So if it's the legislation rather than the application that's potentially discriminatory, this case could be of use. So now, taking a look at the other end of the spectrum, I wanted to just touch on a case involving younger workers and a reference that was made from the Italian courts to the European one. This case involved an Italian national provision on on-call contracts, i.e. contracts where an employee makes himself available to an employer who can assign them work on an intermittent basis, dependent on the employer's needs. So what we would term as a 0 hours contract. Under the Italian legislation, these contracts could be used by employers regardless of the age of the worker, where certain objective conditions were met, and those were to do with the nature of the services being performed being intermittent according to requirements specified in collective contracts between employers and employees associations. But secondly, this bit of legislation could also be used in any event for workers aged under 25 or over 45, i.e. that objective condition didn't need to be met. And for workers younger than 25, the national provision had been construed as entailing an automatic termination of the relationship on that basis when the age of 25 was reached. So in this particular case with Abercrombie and Fitch, the employee had been employed by them on an on-call contract for around 1.5 years. And when he turned 25, he was no longer included in the work schedule. So up until that point, he'd been given fairly regular work. And after inquiring about this by email, he was told his dismissal had occurred due to the fact that he'd turned 25. So he no longer complied with the conditions for the intermittent contract as laid down by Italian legislation. He felt this was unfair and challenged it as unlawful, and the appeal court in Italy held that it was. But on appeal to the Supreme Court, they said that they weren't sure it had been infringed and gave a reference to the European Court on whether the Italian provision on these on-call contracts, to the extent it contains specific access and dismissal conditions for people under 25, was contrary to the principle of non-discrimination on grounds of age under the European Directive. So the Italian government put forward a number of different reasons underlying the measure. They said that it allowed for the first opportunity to be employed by individuals, so allowing for initial and subsequent relevant experience on the job market, even if that wasn't stable employment. They said it was part of a legal framework aimed at promoting flexibility in the job market, i.e. to increase the employment rates. And it was aimed at fostering the entry of young people into the labour market in the first place. And in the opinion, the Advocate General said that each of the aims put forward by the Italian government could constitute a legitimate aim, but that clarity of aims was needed. It was then up to the member states to determine what was appropriate and necessary, but the Advocate General did comment on the fact that with promoting flexibility in the job market, the National Court must decide whether flexibility only for specific age groups was appropriate, and that needed to be balanced against precariousness and clusters of the job market. On facilitating youth employment, the National Court said, they said again it's for the National Court, but they need to examine whether there were less intrusive alternatives to automatic dismissal. And on providing employment opportunity, again, for the National Court to ascertain, but also to look at whether less onerous means could have been envisaged. So the conclusion was that the directive for equal treatment in employment must be interpreted as not precluding national legislation such as this, but as long as that legislation pursues a legitimate aim linked to employment and labour market policy, and it achieves that aim by means which are both appropriate and necessary. It's worth mentioning this was the Advocate General opinion, so it might not be followed by the European Court. It will be interesting to see where this ends up, particularly in the wider context of where zero-hours contracts might be heading, given the likely disparate impact they do tend to have on younger workers. Interestingly, this was the first, but probably not the last reference inviting the courts to consider a national measure, which includes specific conditions for younger workers in regard to access to a particular type of flexible employment contract. So what lessons can we learn from all of this? Well, one which we suggest is formulate your legitimate aim prior to implementation of a policy so that you've really thought it through and so that it can be legitimately rationalised. Don't just link it to the age of a worker, because that is a shortcut, but it's not one that is without significant risk. Think carefully about the wording of any legitimate aim. And if you are targeting a particular age group, think about why. And then finally, ensure you have a lot of evidence to back up your aim, because the courts will look behind it. So on to...
Yep, so we're going to have our second poll now. What we're asking you is if you've ever had to consider objective justification for a potentially age discriminatory practice, have you set out your analysis and evidence in writing? So if you've had provisions that might be potentially discriminatory, have you recorded the objective justification? Essentially. So the options there are yes, no, or I don't know. So just waiting for some of the responses to come in there. It seems from the cases, if there are some common threads there, then evidence and being able to prove that evidence and that thought plan is definitely something that the courts and tribunals are looking towards.
Absolutely, Ian, yeah.
So that's interesting how it's a very mixed bag there, but with a lot of people saying that they don't know, and that could be very interesting that perhaps what the courts and the tribunals expect might not be actually what people are doing in practice, and there's often that disconnect between the very high standards expected and what is actually happening on the ground when you've got 1,000,001 things to actually be getting on with.
Yeah, and I think that's also true in terms of some practices might have been in place for donkey's years, and actually there's never been any cause to assess whether actually, if they give rise to potential age discrimination issues, what might have been the rationale for putting them in place in the first place, and whether we can rationalise them now. So that might also explain why perhaps provisions or practices just haven't had that thought process attached to them.
Yeah.
Okay, so I'm going to move on now and talk about some of the recent policy developments we've seen for the first part of this year. And I think some of these really can be broadly summarised as intergenerational fairness, which is something that came through in the general election as well. So really the question of how the social contract is affecting younger, older and middle-aged people. And the first one that I want to mention is an independent report that we had from John Cridland, which examined how to judge the best balance for a fair and sustainable state pension age. And this continues to be a really big issue in terms of what the state pension age currently is and whether it needs to move upwards in future. And it's particularly in recognition of the fact that in 1908, when the state pension was originally introduced, it was available to those aged 70, which is a pretty old age, and actually only 1 in 4 people at that time would ever reach that age. And even if they did, they might only expect to live for a further 9 years. By contrast, a baby girl born in 2017 can expect to live until she's 95, a baby boy to live until they're age 91. Meanwhile, those already in receipt of the state pension age are currently expected to live for at least 20 years. So there's that real desire to balance providing a state pension as against the recognition that the growing and ageing population will require some pretty significant funding by taxpayers in order to remain sustainable over the long term. So John Cridland's review concluded that state pension age should increase to 68 between 2037 and 2039 to provide a greater measure of intergenerational fairness and to make the state pension more affordable. And state pension age should not, however, change more than once in a decade, with at least 10 years' notice of the change to be given, so that people feel that they've been properly consulted with before that happens. But what I thought was particularly interesting about the Cridland report was the fact that, although this was ostensibly a review of the state pension age, it also wanted to consider a more holistic approach to the changing demographics of the population. So whilst it had those recommendations for how the state pension age might rise over time, it had a number of policy suggestions that would sit alongside this to smooth the transition to an increased state pension age. And these policy suggestions included that all employers should have elder care policies in place which set out a basic care offer, that the government should directly support a statutory carers leave programme, that people should be able to access a midlife career MOT and review facilitated by employers and the government, with the intention that this supports a gradual transition to retirement. And also, interestingly, that the government's 2017 review of automatic enrolments thinks a little bit more about improving coverage for women, so for example, possibly following the Swiss model where couples are given the option to combine their pension savings to make up for many women's absence from the labour market due to caring responsibilities. And also, Cridland suggested that automatic enrolment is opened up to the self-employed as one of the identified groups who are currently more likely to find it difficult in terms of having to keep working up to the state pension age because of their lower private pension savings. So I thought that was quite interesting in terms of what we had around state pension age, and also in terms of some of the points we're going to talk about from the general election manifestos. But I'm just now going to hand over to Ruth on another report that we've seen.
Thanks, Liz. Well, yeah, I just wanted to again look at the other end of the spectrum and this idea of intergenerational fairness. So the Resolution Foundation Intergenerational Commission report said that the social contract between generations is showing signs of fraying. Of particular relevance, I think, to questions of intergenerational fairness is evidence that the pay of today's workers has been suppressed to some extent by firms filling deficits in defined benefit pension schemes that provide for older or retired workers. And this generational concentration of wealth is being driven in no small part by the closure of access to those schemes to younger workers. Instead, younger workers have to make do with defined contribution pensions. The introduction of auto-enrolment is providing an important boost to coverage, but average contributions are below 5%, with just 2.9% coming from employers. And in the absence of significant improvement in these figures, millennials face much more uncertain retirements than the baby boomers currently entering this phase. According to the Pensions and Lifetime Savings Association, almost half of 35 to 54-year-olds are looking to property to finance their retirement. However, 23%, or 1.9 million, within this group have yet to buy a property, which suggests that some may be basing their future financial security on an asset that they might not ever own. So what does all this mean really for trustees and employers? Well, this continues to be a transitional time in the world of pensions and HR and a lot of other things, as age and intergenerational unfairness continue to frame the discourse to some extent. And perhaps approaches like the one in the Abercrombie and Fitch case we discussed earlier will be looked at more, but employers of choice will be those that look to close this gap rather than inflate the discourse and target a holistic approach that takes into account the wants and needs of all their workers of all ages.
Well, as Ruth mentioned, we felt we really couldn't finish today's All About Age webinar without mentioning the recent general election, not least because so many of the main political parties' manifestos touched on issues which affect different age groups. So, for example, housing allowance for younger workers, tuition fees, changes to the state pension age, whether or not to change the triple lock, not to mention the debate around the future provision of social care and how that is to be funded. In fact, we felt that there's a compelling argument that with so many of the debates in the lead up to the election touching on issues of intergenerational fairness, we might conclude that the general election 2017 was all about age. So what do the parties say on some of the cornerstone HR issues? Well, I'm going to whiz through mine on pensions aspects. So we have the state pension age, I've already mentioned the Cridland report. The Conservatives were looking at recognising the need to continue to provide the state's pension, but at the same time protecting each generation fairly, which I think suggests that, reading between the lines, the Conservatives would be minded to increase the state pension age in line with the Cridland report. Meanwhile, Labour rejected proposals to increase the state pension age beyond age 66 to 2020, and instead wanted to look at reviewing the pension age, taking into account particularly wide variations in life expectancy and the arduous conditions of some work. We had different party views on the triple lock introduced by the Conservative Lib Dem coalition government in 2010, and now an acceptance by at least the Conservatives that whilst the triple lock increased every year by the higher of inflation, average earnings or minimum of 2.5% might be maintained till 2020, but actually then it would be better to introduce a double lock, so removing that 2.5% annual floor, accepting that Labour and the Liberal Democrats think that the triple lock should be committed to maintain for this Parliament. And then in terms of party-specific manifesto promises on older workers, well, there wasn't actually quite a lot about older workers. As I've mentioned, there were plenty of policy decisions which did bear on older people generally, but not older workers in particular. So what about younger workers, Ruth?
Well, from looking at the main party manifestos, apprenticeships are here to stay as a way to help young people in particular enter the job market, but there was divergence amongst the main parties on how these would be delivered and in particular how they would be monitored for quality. The changing nature of the economy, so this gig economy we keep hearing about, was given reference in most manifestos, with Labour saying they would ban 0 hours contracts and the Conservatives saying they will review the report from the Matthew Taylor review. And finally, there was some divergence on wages policy, Labour looking to extend the living wage in particular to those over 18, and the main parties were commenting on wages in a way which will be likely to impact on younger workers in particular. So how did all this impact voter turnout? Well, I'm probably not short-sighted enough to think that HR policy was the main thing affecting voter turnout, although it probably will have fed into the larger discourse that we've been touching on around having a fair social contract that listens to the needs and priorities of all ages in this country. So there were lots of figures being lauded around on Friday about youth turnout. 72% was one that I saw a lot, saying there was 72% turnout amongst 18 to 24-year-olds, but it isn't clear exactly where that figure came from, so it may end up that that was, in the words of Donald Trump, fake news. A latest poll from Lord Ashcroft did show that around 2/3 of those aged 18 to 24 said they voted Labour, as did more than half of those aged 25 to 34 and 50% of 35 to 40-year-olds, with only 30% of that age category voting Conservative. But that was a relatively small poll. There will no doubt be much further scrutiny and analysis of the numbers in the weeks and months to come. But we do leave you, as Liz said, with the thought that the election was, at least in part, all about age.
Yep, and I think that's the first time that in any of our webinars we've had a direct quote from President Trump, so maybe there'll be more of those to come. There's also going to be some interesting discussions today between Theresa May and Arlene Davis of the Democratic Unionist Party. The DUP manifesto, like many of the other parties, had a commitment to retain the state pension triple lock, so there's already a tension there, and the DUP does tend to be slightly, well, not even slightly, far more left-wing on economic issues and things pertaining to HR than the Conservative Party, so there'll be some interesting stuff there. We've had some great questions come in. We've got time just to cover a couple of them. The first one is very common scenario where you've got a defined benefit or final salary scheme and there's a project